This video is intended to introduce you to LRW oral arguments. First, we'll talk about why we have oral arguments in legal research and writing. Second, I'll talk about how the process works. Third, we'll discuss some common pitfalls, both substantively and regarding the presentation. Later, you'll have an opportunity to practice both in pairs and in small groups, and I'll be available to answer your questions. First, why do we have practice rounds or oral arguments in legal research and writing? Number one, it helps you develop your analytical skills. As you learn the analysis better, you'll be able to write better. Years ago, I had a student suggest that we do practice rounds in the middle of writing the brief because having to explain your analysis in this setting proves to you what you know and where you still need to work. Second, related to that, some students learn the analysis better by talking through about it than sitting in classes, reading cases, listening to lectures. Second, oral arguments prepare you for real-world lawyering. Even if you don't expect to go into litigation, there are a number of ways that you're going to be required to draw on the skills that you develop through oral argument. For example, you may have to provide legislative testimony. You could have to talk to a board of a corporation that you are advising. When I was in practice, I had to make presentations to other attorneys in my office about new developments in the law and for job interviews. All of these require you to plan what you're going to say, anticipate questions, and think on your feet. So the process for oral arguments in LRW are available to you from the frequently asked questions that's posted on Canvas. The practice rounds take place in the library in small rooms. Based on the frequently asked questions, you should be able to determine who are the judges for practice rounds, how long does each side argue in practice rounds, which time cards will you see, and what you should wear. This is what the room will look like when you enter. Two of the tutors will be serving as practice round judges. There'll be a lectern and cards indicating where the appellant and the respondent sit. For your final oral arguments, our arguments will be the Tuesday and Wednesday after spring break. They will all be in room 141. And now I'm going to show you an example of a final oral argument. In that example, please listen for the following. How does the advocate introduce himself? How does he tell the court what his client wants? How does he outline his argument? Notice that he stops for questions from the bench. Notice he answers questions directly. And then he moves back to the key points of his argument. Notice too, around minute 4, that he refers to the authorities. For example, he mentions the Lopez case from the 10th Circuit. Even though this is an argument on a problem that you aren't familiar with, you should be able to understand some of the fundamentals of oral argument from watching it.
Thank you. The next case on the docket is United States versus Levine. Counsel, you may proceed.
May it please the court, my name is Franz Brugmeyer, counsel for appellant Angela Levine. I'd like to reserve 1 minute for rebuttal.
Okay.
Thank you, Your Honor. This court should reverse the district court's ruling for 2 reasons. First, Ms. Levine was seized, and second, the evidence at issue should be suppressed under the exclusionary rule because it was discovered due to the exploitation of her seizure. The event the rule was created to stop.
Counsel, what's the standard review in this case?
It's de novo.
Is that for both issues in this case?
Yes, it is. So I'll start with the issue of Ms. Levine's seizure. The Supreme Court has given us a test whether an individual has been seized, and that is whether, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. The test is not whether the person was technically able to leave, technically legally able to leave, whether they were physically able to leave, but it's whether a reasonable person under the totality of the circumstances would feel free to leave.
It wasn't her driver's license they took, though, right?
It was not, no, Your Honor.
She was only, what, a couple blocks from her house?
That's correct, Your Honor.
What prevented her from leaving at that point?
I think that a reasonable person is not going to leave their possessions, is not going to leave something that takes time and money to replace and that is used every day.
Well, I mean, I'm not going to think the police are going to steal it. She would have assumed that she could have gone back to a police station and picked it up.
Again, the test is whether a reasonable person is going to feel free to leave, and under those circumstances, a reasonable person is not going to leave, according to a few of the courts that are cited in the brief.
Counsel, you talked about seizure, though. I mean, the record reflects that this wasn't a hostile encounter anyway by the police officers, correct?
That's correct, sir.
Lights weren't on the vehicle.
No.
Guns weren't drawn.
No, Your Honor.
They didn't use any type of commanding tone or voice, did they?
No, Your Honor.
Okay. So what's the problem?
So the circumstances are this. Under these circumstances, when two armed uniformed officers pull up in a patrol car, double park in the street next to you, as she stood on a public sidewalk talking with a friend, they approached her and engaged her in conversation, asked questions, separated her from her friend, each officer talking to one individual.
That's interesting, but the Supreme Court in INS versus Delgado, I believe, articulated some points, none of which are the points you're articulating now, right?
That's correct, Your Honor. But the test is under the totality of the circumstances. These aren't check mark boxes.
They're not?
No, they're not check mark boxes. It's a totality of the circumstances test. So you have to take the circumstances as they are and decide whether a reasonable person would feel like they were free to leave that circumstance.
Counsel, does it matter for how long they held on to her identification?
No.
So your argument is it would be a seizure if they took it for all of 5 seconds just to verify that the name she gave them was correct.
Your Honor, let me clarify that. With Lopez in the 10th Circuit, sorry. The argument is that checking the identification and making sure that she had not given false information, which is a crime. Once he had done that and verified that she was who she said she was, she lived where she said she did, holding on to it beyond that is when a reasonable person is not going to feel free to leave.
Okay.
So, as you noticed in that argument, the student had a set of notes with him. You should all have one folder of notes that you take with you to the lectern. In that folder, you should have 2 sheets of paper, and you should tape them to the inside so that they won't move when you open the folder and they won't fall to the floor. One of those pieces of paper should have the outline of your argument, your introduction of yourself, your key points that you need to make. And you notice that as he was making his argument, sometimes he looked down at his notes to remember where he was and to continue the argument after questioning. The second piece of paper should have a list of authorities. This should not be the detailed list that you gave me as an assignment last month, but it should simply list the authorities with perhaps the circuit and a few key points that you might need to jog your memory to answer a question. Make sure that what you've written in this folder is in large enough font for you to be able to look down quickly, read it, and answer a question. Your goal is not to condense your entire brief to 2 pages that you will then read to the court, but to have notes that you will refer to as you engage the court in a conversation. Let's talk now about some substantive pitfalls that you might run into when you are preparing for your first oral argument. Number 1, Memorizing a speech. Sometimes students think that if they could just memorize everything they need to say, they'll never have to answer a question, and they'll make a beautiful presentation. That's not the goal. The goal is to listen to the judges and answer their questions and engage them in a conversation. Second pitfall is forgetting the purpose, which is to answer the questions, to clarify your brief. You need to expect to get questions. The time will go by faster. It'll give you time to catch your breath. And the real purpose of this oral argument is to have a conversation with the bench and make sure that you have answered any questions that the brief might have caused. Number 3, a big pitfall is not answering the questions, not being responsive. Notice that words coming out of your mouth doesn't mean you're answering the question. You really do need to hear what the judge's concern is and provide information that is responsive. Fourth problem is delaying an answer. A judge might ask a question that you know you're going to address in your outline in just a few minutes. You can't tell the judge, "I'll get to that later." When the judge asks a question, you must answer it immediately. Fifth is not answering clearly. You noticed in the video, the student frequently said, "Yes, Your Honor," "No, Your Honor." Try to give that definite answer first, and sometimes that's enough. Try not to wander around looking for an answer and hope that you stumble across something smart to say. It's better to stop and think for a few moments. You don't have to answer immediately. This is a conversation. Judges ask hard questions, and they're not surprised if you have to take a moment to answer. Number 6 is getting off your argument. After you've answered the question, you need to pull it back to your outline, to your understanding of what the judges need to hear and think about if they're going to decide the case in your favor. So after you've answered the question, tie it back into your argument. For example, if the judge asks, "Does the legislative history mention the hospital's motive?" you could say, "No, Your Honor, but it does discuss discrimination." And then you go on to talk about the Cleveland court. Seventh problem is not expecting follow-up questions. You think you're going to answer a question and move back to your outline. But as you noticed in the video, there's a lot of back and forth. Don't ask a judge if your answer to the question is sufficient. Assume that it is. If the judge has a follow-up or wants to repeat the question, that's the judge's option. Number 8, don't ignore the law. You're using legal arguments, precedent counts, and you have to refer to cases when it's appropriate. 9 is not using transitions. You're going to have 2 major points to argue. One is how the statute should be interpreted. The second is whether summary judgment should have been granted. And within that, you're going to have several points that you'll want to raise. So you're going to need to use transitions to let the judges know where you are. You might say, continuing with the second point, or that leads to my third point, or turning now to the summary judgment question. But use those transitions to keep the judges focused. The 10th problem is not recognizing friendly questions. Don't assume that every question you get from a judge is trying to trip you up. Sometimes the judges will ask you questions just to advance your argument. In the real world, a judge may ask you a question to try to convince another judge what the answer is. Another pitfall is not preparing for hypotheticals. Just as your professors in your doctrinal classes ask you hypotheticals about cases, you should anticipate that the judges hearing your oral argument are going to ask you hypotheticals about your case. What about a case where a woman shows up in labor without insurance and sees a nurse circle and read a blank portion of her info asking for insurance information? How would your interpretation of the statute apply in that situation? The 12th is not preparing for basic questions. There are a few basic questions that every advocate should be able to respond to. How is this issue preserved for appeal? The simple answer for ours is that this was the subject of a motion for summary judgment, and the court granted it. Number two, how does this court have jurisdiction? You know from your brief that the court has subject matter jurisdiction because it's a federal statute, and has appellate jurisdiction because it's from an order granting a motion for summary judgment, which is a final order. Number three, what's the standard of review? You have to go beyond knowing the words de novo and know what that means. And finally, do you have to win on both issues to prevail? The answer will differ whether you are the appellant or the respondent. Let's talk now about some presentation pitfalls. Number one, stay behind the lectern. Don't go wandering around the courtroom. Number two, take your folder with you. If you don't take any notes to the lectern with you, the judges are going to think you're being a little bit too self-assured, a little too confident, and might hit you with some harder questions. Next, keep your hands resting on the lectern as much as possible. It's fine to emphasize a point, but for the most part, your hands should be on the lectern, not at your sides, not playing with your hair, not pointing at the judges, not tapping your pen. Keep your weight on both feet. Don't sway, don't rock back and forth, don't lean forward and lean on the lectern. Use a loud, clear voice. It should be loud enough for the judges to hear you, but not so booming that they feel overwhelmed. And try not to let your voice go up at the end of the sentence. Whenever we have our voice go up at the end of the sentence, we act like we aren't sure, as though we're asking a question, or maybe we're not sure of what we're saying. Try to avoid that. Make sure that you talk only while you're at the lectern. Don't walk while you're approaching it. Don't walk as you're leaving and folding your folder. Just talk while you're standing firmly at the lectern. Finally, what do you say when your time is up? We have made this easy because we have time cards that show 5 minute, 3 minute, 1 minute, and time is up. If you see the time card go up, you say, "Your Honor, I see my time is up. May I briefly finish answering your question?" Or "May I briefly conclude?" And make sure that you are very, very brief at that point. You should try to end your argument before the time is up card appears. When you see 1 minute is left in your argument, you should try to finish saying whatever point you're making and move to a brief conclusion.